And this is the third Max Weber program book roundtable this academic year. So just to remind you, the criteria for choosing a book are: it has to be an important book, it has to be a recent book in the social sciences, it should tackle a major topic of our times, and it should appeal to a broad and multidisciplinary audience. And once again, I cannot imagine a book that fits better than Katharina Pistor's most recent book, The Code of Capital: How the Law Creates Wealth and Inequality, which really meets and exceeds these criteria. So the book examines how assets such as land, private debt, business organizations, or knowledge are transformed into capital through contract law, property rights, collateral law and trusts, corporate and bankruptcy law. When I was trying to summarize the book, I remembered that a couple of months ago, I read a review of it by Adam Tooze, and actually I went back to that review and I realized he's still better at summarizing this as my. So I just read you what he writes about the book in his insightful review that he published in the New York Review of Books, I think. So what he writes is: the Code of Capital brings together the ferment in American law schools and the more broad-based continental critical tradition, with concerns derived from Thomas Piketty's history of inequality and recent thinking within so-called heterodox economics about the unstable nature of financial capitalism. The result is nothing less than a crisis theory of law. Law, as it currently functions, is, for Pistor, constitutive of the order that creates and perpetuates inequality, opacity, dysfunction, and crisis, and ultimately puts at risk the legitimacy of the rule of law as such. This important book was also named one of the best books of 2019 by the Financial Times and Business Insider, and it has just been translated to German. This is why we have the book roundtable right now, even if most of you actually don't read German. But for me, it was a big pleasure to see that it came out in German. So let me briefly introduce also our guest to you, although I fear that Katharina Pistor does not really need any introduction here at the EUY. So she is the Edwin B. Parker Professor of Comparative Law at Columbia Law School. She's a leading scholar and writer on corporate governance, money and finance, property rights, and comparative law and legal institutions. She is the co-author or author of about 9 books, including Governing Essential Resources, which came out with Columbia University Press in 2015 and co-audited with Olivier de Schutter. Legal Origin Theory came out in 2012 and was co-authored with Simon Deacon. And Law and Capitalism: What Corporate Crises Reveal About Legal Systems and Economic Development Around the World, which came out in Chicago University Press in 2008 and is co-authored with Curtis Milhaupt. Pistor has received numerous awards and also has published widely in legal and social science journals. I should add here a personal note. So when I came across for the first time in my career, came across Katharina Pistor's work, it was in 2008. I was a Fernand Braudel fellow here at the EUY, and it was the great financial crisis. And at that point, she wrote a piece that was really an eye-opener for me, which was called Into the Void: Governing Finance in Central and Eastern Europe. This piece has had a deep influence on my own work, and ever since I have been following Katharina's work, and it has always been an eye-opener, and so has been her recent book. So I'm very, very pleased that you have accepted our invitation, and I'm only sorry you cannot be here in person, but I hope that we will be able to make up for this at one point. So welcome, Katharina. Before we start, let me briefly present the members of the panel. So we have Katarzyna Doniec, who is a Max Weber Fellow in SPS, so Social and Political Sciences, and who works on social determinants of health. We have Alvaro Pereira, who is a Max Weber Fellow at Law Department and who works on the relationship between corporate governance, economic growth, and society. We have Giacomo Tagiuri, who is also a Max Weber Fellow at the Law Department, who specializes in EU law, regulation, and economic law, And last but not least, we have Martijn Hesselink, who is a professor of transnational law and theory at the law department. I'm very pleased that you all accepted and volunteered for discussing this important book. The format is relatively straightforward. Katharina has 10 minutes to just remind people briefly about the main arguments of the book, and then each respondent or each panel member has up to 10 minutes for their intervention. And at the end, I give Katharina the word again, or the floor again, to respond to some of the criticism, and we can open to the public, and the whole event will last between an hour and maximum 90 minutes. So once again, welcome, Katharina, and the floor is yours.
Thank you so much, Doro, for inviting me, and thank you all for coming to this event. It's really a great pleasure for me to be here, at least virtually. I would love to be in Florence. I've traveled a lot. I spent quite some time at the EOI in the past, and I'm looking forward to coming back. So let me just dive into the main argument very briefly. The critical question that I'm asking myself, that many have asked before me, is what is capital? You know, what are the ingredients of capital? And the term has been used since the 16th century, at least. The way I define capital, I follow Piketty and others who basically say it's a wealth generating and possibly also wealth protecting asset. But that's just the descriptive side of things. What I'm trying to do is really to go inside and understand the techniques that make something a wealth generating or wealth protecting assets. And I identify 4 attributes that a simple object, interest, or promise must have to be turned into capital. And these 4 attributes are priority, durability, convertibility, and universality. Let me briefly explain each of them. Priority basically means that we rank claims to an asset. A holder with stronger rights has priority over holders of weaker rights. So that's something the law does, and it helps us resolve dispute, because if you have a stronger right, you can take it, and others have to yield. Durability means that we are extending these rights in time, mostly by creating legal shields or legal veils that protect certain objects, interests, claims against too many claimants. And I'll talk about the devices we use in a second. So that's durability. It basically makes sure that these assets can incubate and thereby create wealth, can grow and create wealth over time. Convertibility is basically the way in which financial assets attain durability. Convertibility does not mean just that we can transfer an interest or claim or object or assign it to somebody else, but that we can have even a claim like an option that we can convert it preferably into a safer asset. And the safest asset of all in the end is state-issued legal tender, state-issued money. So if I have an option to convert my asset at the central bank into something safe in times of crisis, I'm much better off than if I have to hold on to an asset that has been issued by a private party that might lose its nominal value in times of crisis. So that's convertibility, particularly relevant for financial assets. And then last but not least, universality means that these different attributes, priority, convertibility, durability, will be enforced not only between 2 contracting parties, but are enforceable against the world. Erga omnes, as we like to say in Latinese as lawyers. So property rights are universal interests. You learn this in the civil law system. In common law, it's slightly different. They're talking about a bundle of rights, but the universality aspect that you can enforce it against third parties that weren't part of the deal is there as well. Now, how do assets attain these attributes? They attain them through a handful of legal institutions, and these are legal devices. I call them modules in the book. I'm basically saying the code of capital is legal devices. I'm talking code, not codification, because I'm interested in the process of coding assets as capital. It basically means that you graft. If you think about, just putting a branch of an apple tree on a plum trunk and creating a new fruit. So in that sense, you graft these type of legal attributes onto different assets. And the core institutions that we've used for centuries, and the remarkable insight for me was to realize at some point how continuous these devices have been, is property law, collateral law, which is a subcategory of property law, the common law trust, corporate law, bankruptcy law, and contract law. So property law creates ranks. If you have property, you can take it out. The asset test to see how strong your right is typically bankruptcy. So in bankruptcy, by definition, defaulting debtor no longer has enough assets to satisfy all creditors. So if a creditor has a stronger right, if somebody has actually an interest, a property interest in an asset that is in the position of the debtor, he or she can take it out. If I have collateralized, secured my interest, I can take it out, and all the other creditors have to yield. So you see the universality aspect to that as well. We use corporate law and trust law to create legal shields to protect assets against too many claimants, including tax authorities that want to put their hands on assets. We throw them behind a trust, we incorporate another entity in the Cayman Islands, and thereby can protect them from different claimants. Bankruptcy law, I said, is the asset test for seeing what, how much worth or how strongly different rights are. But bankruptcy law also creates its own rules. It has its own priority rules. It says basically which creditors can take out something first. It tries to replicate the rights that we have contracted outside bankruptcy, but it sometimes also creates its own priority rules. Just think of bankruptcy safe harbors. So bankruptcy safe harbors are rules that allow some holders of some assets to be exempted from the ordinary process of bankruptcy and to enforce basically their claims even with a defaulting debtor by netting out their interests as everybody else has to stand aside. Once we create something like that, we create de facto a new type of property right. Contract law finally is sort of a flexible device. It's the paradigmatic bilateral legal device, but it also can be used to mimic the hierarchy of interest in bond covenants or in securities transactions. We use contract law to basically recreate hierarchy by creating different types of rights to the same cash flow, which are all de facto contractual rights. So I'm basically then showing in the book how we have used over time property law, contract law, collateral law, corporate law, bankruptcy law, and to code different assets as law. And the book basically walks you through different assets: land, debt, firms, and ideas or know-how, intellectual property rights, and I push it all the way to the code of nature, the DNA, the extent to which the genetic code has become an object of intellectual property rights and therefore has become encoded in law and used for the benefit of some who could create a monopoly right to particular sequences of the code or particular alterations of the mRNA to extract wealth. So the argument in the book is, without having these kind of attributes, you need 3 out of the 4 that I mentioned. So convertibility and durability, I told you were exchangeable. So if you have 3 out of the 4, you have a comparative advantage over everybody else. I'm not saying that you're creating absolute rights that will never budge, but I'm saying that relative to all other claimants, you are better protected, and that is what gives you a stronger right and stronger interest and allows you to generate wealth over time and to protect it against future loss. So if I can convert my financial assets at the central bank in times of crisis, I'm basically locking in past gains and thereby securing them, and can then reinvest them once the markets have become calmer. Let me just say a few words about the role of the role of the law and the role of the state, because that's really critical. There is a hidden and not quite explicit theory of the state in the book, which basically says the state, as Max Weber has suggested, is sort of the centralization of the means of coercion. But in constitutional democracies, these centralized means of coercion, can be institutionalized in different ways. We should not think of the state just as a single agent, an actor that works against society or tries just to order society, but it's basically a centralized resource. And the question is, how do we organize? Who has access to this resource and can use it against others in what fashion? So lay people very often think about law as a vertical instrument of ordering by a state vis-a-vis society. Or maybe human rights scholars think of human rights as rights that they can invoke against the state, again in a vertical fashion. I'm thinking about horizontal relations. I'm thinking about how people organize their relations with one another in the economic sphere through contract law, property rights, collateral law, et cetera, et cetera. So that's the point. And what is happening here is that if you know how to avail yourself of these institutions, you are invoking state power, because it's basically by using the law, you're assuring yourself of the enforceability of your claims, and thereby are scaling your relations beyond a bilateral relationship. You can scale relations into anonymous markets that span the globe. And that basically, that framing then allows me to say, we have, you have to have the source of power behind you, but you can extend it actually beyond the territory of a single state through a couple of mechanisms. The one that I find most fascinating is international private law, or choice of law, conflict of law rules, as sometimes called in the Anglo-Saxon world. And that basically means that domestic law of different countries determines under what conditions it will recognize and enforce foreign law. And as we have liberalized these international private law rules, these choice of law rules, we have expanded private autonomy so that over more and more types of claims, private party can choose the law that applies to them. That means they're still dependent on some state, but they're not dependent on a single state, not necessarily on the state where they're from or where they operate, because they can basically pick and choose from a menu of legal systems, the ones that best fits their needs, and of course they have to have lawyers at their sides to do so. So the last two things I want to say is, so globalization works mostly through this extension of private law and enforceability around the globe. It is very parochial. The most important legal systems that are used in global financial capitalism are English law and the law of the US, mostly New York and Delaware, if you want to bring it down to the state level. So it's very much hegemony rather than a plurality of legal systems. And it's sustained by law. So you have to always trace it back to power and state law. I want to say a word about the lawyers, and I want to say a word about democracy, and then I will close because I already have reached my 10 minutes, I think. So the lawyers, I call them the masters of the code. They know how to code assets. They know how to harness the powers of private law institutions, the kinds that I mentioned, to code assets for their clients. And when I talk to practitioners in the city of New York, they are quite frank. They basically arguing, when you have public regulation like the Dodd-Frank Act or other financial regulation, it just takes a while to mute their effect on private transactions, because you can take the elements of the code, as I would call them, the modules of the code, and arbitrage around them, or at least mute their cost effect by, again, choosing different laws, finding different legal loopholes in existing regulation. So there's a game going on between the private coding of capital and the attempt to push it back and regulate it, and then of course you code around that again. That process of escaping the reach of domestic law or and democratically set domestic law, and finding your own tools to harness the power of some state to create capital, creates fundamental challenges for democratic self-governance. So that's the major concern. I think that we have outsourced the ability to invoke state power for private purposes to an extent that we have lost the ability to self-govern effectively. And I'm not saying that we should push the system back to autarky or to complete domestic control over legal devices, but I think we have to enhance the ability of key institutions, whether these are courts, regulators, but also legislatures, to ensure that we can, in critical aspects of also economic life, determine the rules by which everybody is governed, rather than allowing some to pick and choose the laws by which they wish to be governed. So let me stop here.
Thank you very much. This was very helpful to get a refresher and reminder about what the main thesis of the book. Katarzyna, if you would like to start with your.
Hello, everyone. I start by saying how pleased I am to be able to share with you my views on Professor Pistor's book. This is a very timely, thought-provoking work and an important contribution to the ongoing discussion in the social sciences about the rise of global inequality as we witness it today. I initially approached the book somewhat timidly, given that I am not a lawyer but a sociologist. However, I want to emphasize that it very soon became clear that the author had gone to great lengths in making law terminology and case studies accessible to a more general audience. The book's main contribution is showing the central the central role of legal systems and private property law in particular in wealth accumulation under capitalism, today as much as in past centuries. Here I allow myself for a quick digression. What a shame we cannot be meeting in Florence today, given the Medici's family role in the development of modern corporation, something that which the author also vividly portrays in the book. In this way, Professor Pistor's emphasis on law in wealth concentration challenges the dominant notion in social sciences that inequalities are a product of economic factors per se. To me, the book tells the story about the inequality of opportunity for wealth creation. We like to think of Western capitalist societies as mostly meritocracies, where everyone competes, if not exactly on an equal level, at least with low barriers for advancement, where ability towards wealth creation is shown. Though obviously we sociologists like to contest this notion. The author does not shy away from exposing the truth that the equality of opportunity for wealth creation simply does not exist, and only those who can afford the best lawyers can acquire legal privileges, allowing for capital creation and accumulation. Given the ongoing debate on the rise of inequality globally, it comes as a surprise that the legal determinants of wealth inequality have not been part of the debate up until now. The debate is arguably dominated by economists, but we have to go back to Marx to see anyone taking property law as a serious threat in inequality. We clearly cannot have a meaningful discussion about wealth inequality rising or about possible policy remedies without a deeper understanding of the role of legal processes. It is interesting to reflect on what has stopped us from crossing artificial disciplinary boundaries towards a common theory of global inequality. Well, there are two reasons for law being a blind spot in the inequality debate, which Professor Pistor acknowledged, but perhaps not as clearly and directly as might have been helpful to those from other disciplines. The first reason is the lack of common understanding of what constitutes capital. As Professor Pistor points out, economic tradition tends to see capital as a physical input, one of the two factors of production and economic growth, such as grain surplus, when in fact this has never been the case, and the key to capital is its legal coding, and almost everything can be coded as capital, including our own DNA. The second reason is the misunderstanding of the law's nature by non-lawyers. The author shows that law is not static but constantly evolving, and this triggers evolution of forms of capital. On the upside, law's inherent incompleteness leaves room for creativity and innovation, as Professor Pistor shows. On the downside, this incompleteness is also the quality which allows for the evolution of various forms of capital, and as a result, the rise of wealth inequalities. Once we challenge these two notions, first about the nature of capital and the second about the nature of law, we can move towards establishing a common theory explaining global evolution of inequality. I believe the two narratives, economic and legal, are not mutually exclusive, and this is the central point around which I would like to build my appraisal of the book. I wish the author had positioned herself more explicitly in the debate and firmly claimed the space she wants to occupy. For example, by giving more attention to how her work fits with the existing theories of inequality, those of Thomas Piketty or Branko Milanovic. This would allow the reader to gain even deeper understanding and appreciation for the enormous theoretical contribution of the book, as well as help to formulate a new macroeconomic theory. For example, in the gross oversimplification, according to the concept of Kuznets Waves by Branko Milanovic. The global search in inequality since 1980s is driven by technological revolution as well as internationalization of capital, which this leading to reduced revenue from taxation and weakened bargaining power of labor. The operation of law adds as positive feedback to increase the rate of concentration of capital. Clearly, these are the processes to large extent enabled by legal innovation and evolution of private property law. I would therefore say that the Code of Capital brings an essential explanatory mechanism to the inequality puzzle. The only further element which I believe would be helpful in combining economic and legal approaches, and which is currently missing in my opinion, is the incompleteness of the timeline for private property law evolution. There is a clear account of the legal evolution taking place in the second half of the 20th century, but we learn little in detail about, for example, post-war period. Well, there's probably some good explanation for this choice, but as a reader, I would like to be told why. The second question I have concerns the geographical focus of the book. The author focuses on English laws and New York State laws with several mentions of international laws and treaties. In my opinion, the book should provide a more explicit justification for this choice of focus. Is it only because of the legal and institutional landscape of these places, which is particularly capital friendly? There's also the issue of the rise of China and Asian economic tigers. It would be good to understand why law in relation to economy there was not at least mentioned as largely similar or largely different. We also know that economic models of capitalism vary in different national contexts. So more attention given to the possible role of law in that would be helpful. Here I want to say that I am very grateful for Professor Pistor's sensitivity to cultural angles in discussing private law's role in capitalism, cultural variation and understanding of property, for example, the Belize's Maya's example, and the persistent colonial legacy of property laws in former European colonies. This, of course, raises a question of whether a decolonization movement within law is attainable and to what extent. Finally, as someone interested in analyzing human behavior, I must ask why there is so little about turning our behavioral online traces into intellectual property and hence capital, something done by tech giants such as Google or Facebook, or consultancy companies such as infamous Cambridge Analytica. The book has a chapter on turning nature's code, human DNA, and related medical innovation into capital and relevant ethical and legal issues. In my opinion, it would be worth mentioning the process of turning our behavioral patterns into capital, that ever-expanding sea of behavioral data from tracking devices or online activities, face recognition technology, etc. Well, it becomes clear that a digital code is enclosing us too. Thank you.
Thank you very much, Katarzyna. Alvaro?
Oh, thank you very much. Well, first of all, I'd like to thank Professor Katharina Pistor for accepting our invitation to this interdisciplinary discussion of the Code of Capital. For me, it is an instant classic that, as we know today, has been translated to many languages, and I'm sure it found places in the syllabus of many academic programs in universities around the world. And I think her commitment to be here and open up the space for debate of these ideas is also a confirmation of her commitment to academia. I mean, her work has been a great source of inspiration for me. And I want to thank the program for the opportunity to share this panel. As I had anticipated, I believe that my colleagues have done an excellent job in clarifying the main arguments, and the author herself and highlighting the important implications that it has. So just at the risk of being repetitive, I would like just to underline my interpretation of the book, to provide context to 3 brief comments for the author and also for the audience to reflect. I must say that, as Doro mentioned before, my background is in comparative corporate law. So I apologize in advance with the audience that my reflections might be a little bit narrow, at least 2 of them. So in my view, the book contends that capital is privately coded, and this happens when certain lawyers convert assets, whether objects, ideas, or rights to future cash flows into capital assets that enjoy priority, durability, and universality. Private capital is possible because there are minimal but crucial legal modules that the author just explained to us. These rules give ample room to private parties to code capital, and states really have to commit to enforce privately made capital, and if necessary, to save financial institutions from collapse, which I think is something that might come up after. So in conclusion, because capital is privately made, those who code the new capital, that is, those who are able to hire the lawyers to code new capital, can increase their wealth, and democracy cannot control wealth distribution. To reach this conclusion, the author decodes capital, scrutinizing the evolution of these legal modules, only to find that they haven't changed as much as the way in which global law firms use them to privately code capital. The legal rules that govern property, trusts, corporations, bankruptcy, and contracts have only evolved to further enhance the private codification of capital. And to me, this is the main realization, that private parties can in fact code capital. So for example, in chapter 4, Professor Pistor explains how the notes and bills of exchange that emerged in the 12th and 17th century paved the way to modern ways of coding capital, such as securitized assets. And this is the place where I'd like to focus my first 2 questions. By way of context, by 2008, the legal modules enabled banks to sell the rights over mortgage payments to other institutions. And then the buyers of those rights could package these rights with similar ones and sell them again. And if all went well, new capital was created when these new assets called collateralized debt obligations, or CDOs, were bought and sold again in the market. And by now we all know, and for those who haven't, I invite you to read the book because this chapter is very detailed, that in telling us the story on how the CDOs hid high-risk debt, also called subprime. And the overexposure to CDOs, or collateralized debt obligations, took financial institutions down together with the entire economy. So one lesson is that excessive freedom for private parties to create this type of assets can have devastating consequences for the economy. Taking this general lesson, and I'm trying not to be too technical about it, but to engage in the bigger argument, my first questions would be, how much has it changed since the book was published? Because the book traces the history of these collateralized debt obligations after the 2008 crisis, doing an autopsy, if we'd like. And my question is grounded in at least the expectation that we all had that with the pandemic, there was going to be an accelerated pace of legal evolution to fix at least some of the mistakes or the things that were undone before. Just to expand a little bit, in the summer of last year, in the summer of 2020, Berkeley Law professor Frank Barnoy wrote a piece in The Atlantic showing that many financial institutions are largely investing in a very similar kind of assets, the collateral loan obligations, or CLOs. So basically CLOs, these new assets, are very similar to CDOs, but instead the underlying payment is not from a home buyer, but from a distressed firm. And this means that even high-rated assets have a high risk of default because they come from distressed firms. Since COVID-19 has hit virtually all industries, the initial risk exposure might be higher than expected. So just as when homeowners all defaulted almost at the same time, most of already distressed firms might default at the same time. And my impression, at least after reading this article by Professor Portnoy, is that the ways of the ways in which these assets are created haven't been constrained enough since the publication of your book. That's an unfortunate realization that I have. So briefly in your book, in your view, sorry, I wonder what was missed in the regulatory reforms that followed the global financial crisis, and whether COVID rescue packages, the money the governments are giving to firms, might right now be deceiving us and showing an image that the economy is in best shape that it might be, because they're preventing these firms that were distressed before from failing, and ultimately they will fail as the home buyers failed before. And finally, in this point, do you think we might use this opportunity to make better reforms as citizens? We can try to press governments to at least constrain the ability that financial institutions have to create these assets. And very briefly, my last two questions. The second one is related to this ability that certain private parties have to code capital, but in the hands of less regulated entities, and that I perhaps missed in the book, but I would like to hear your thoughts, which are startup companies, venture capital firms, and private equity firms. That is actually the scope of my research, and I wonder, how do you feel that they have used these powers? Just to explain briefly to the audience, stock markets are shrinking all over the world, including the US. That means that less firms are raising capital in the public markets, and this process correlates with the expansion of private markets, meaning that larger firms are raising funds privately, even even less exposed to observers, if I may. And this, in my research at least, suggests that there are new assets that we haven't been studying enough. For instance, convertible preferred stocks. You mentioned in the book a good one that is initial coin offerings, but that one diminished quickly. But there are other assets that have been created in these expanding private markets. I have been documenting how the expanding private ordering nature of company law, the regulation of not-listed companies around the world, is liberalizing and has fostered the emergence of new financial assets outside of the scope of regulators. And I wonder how, in your opinion, might these trends affect the tools that regulators and legislators have to constrain the creation of new assets? And just finally, if I may, I believe I still have 1 minute, just a question for everyone here. One of the recipes or the points that is addressed in the book is the role that we as academics have in contributing to solutions. So the book has a whole chapter dedicated to lawyers, and it documents how law schools and law firms have these perverse incentives that kind of train us to be narrow-minded and simply look at the rules, and we become experts in coding capital without thinking much about the implications. And very skillful students have never the opportunity to even try other things because they have huge debt. So as a lawyer, and having also studied in the US, I had a direct experience in this aspect. But I wonder, beside the law schools, how else can we contribute to solving this problem? And in my view, I would suggest and invite everyone to reflect on it. I think we have a responsibility as academics to improve financial literacy. So many of these issues are not clearly explained to the public, which in my view contributes to how voters make poor choices or are easily misguided. And I think perhaps I think that this book is a clear statement on how should we move forward, but I welcome further thoughts and suggestions from you. Thank you very much. It is indeed a pleasant honor to be here.
Thank you, Alvaro. Giacomo, would you like to follow up?
Thank you. I second my colleagues in thanking the Max Weber program and Professor Katharina Pistor for this opportunity. And I think, as this discussion shows, this book is really reshaping public debates on the governance of the economy and inequality. As it has been mentioned, Professor Pistor's book contributes to the debate on the current growth of inequality and privilege in the economy. As we are more and more aware, and as the Code of Capital reminds us, such level of inequality is not a problem only for those who have less, but for all of us, because it fundamentally threatens the very future of our democratic society. As the book's concluding passages warn us, if we're unable to reverse the trend in distribution patterns, we risk that crude power will sway over legal order. The argument of the book is that the present level of wealth and inequality is the product of law that is used to systematically privilege certain assets over others. To be privileged in our times are chiefly the holders of roving financial capital over the holders of less mobile and more tangible assets, small businesses, real estate, as well as more broadly, probably workers and consumers. The book contribution, however, is deeper. It goes to the essence of what capital is and what capitalism is. As the book shows, the ability of certain assets to produce wealth, to become tradable and to be monetized, which is to become capital, is not in any meaningful way a feature of the assets themselves. And this may be intuitive for, intangible assets like intellectual property or financial assets, but for me it was less obvious about tangible assets, which is land, real estate, and firms. On this account, changes in patterns of accumulation are driven by innovations in the legal code, rather than any inherent tendency of capital to grow faster than the economy, as for example Thomas Piketty would have it. Or for that matter, any exogenous factors like technology or ideas. That's at least my reading. As already amply mentioned, interestingly, the ways in which an asset is turned into capital are constant across the many historical contexts Katharina Pistor books considers. Capital is created through coding, which is the quilting of different legal modules, property, contract, trust, and collateral, into a patchwork, which dresses the underlying asset and gives it the attributes, priority, convertibility, etc. The textile or knitting metaphor, which the book employs, I think works well because of the contrast between the simplicity of capital's modules, the threads or patches, and the sophistication of the final work, which is the patchwork of capital. The metaphor works well also because capital is the product of legal creativity and imagination. The knitters are private lawyers who, after the coding, are able to bring upon the new assets the promise of state enforcement. I want to emphasize two lessons that I draw out of the book. I think the book powerfully shows them, and I think may be useful for the research of many of us. The first one, which is something I did not get immediately, but it became clear as I read, is that capital is not all the same. There is a hierarchy of capital, and capital holders are not all equal. So what capitalists try to do is get at the top of the pyramid of capital by gaining the four attributes. This means that the markets the book describes, and especially financial markets, are not flat, but hierarchical. These markets are as much about voluntary exchange, free choice, and persuasion as they are about power and privilege. And I think the book at some point states it explicitly, the pervasive role of hierarchies and power in the market is one defining feature of capitalism. A second important insight that I take away is that the market is not a homogeneous and a historical reality, as some economists may describe it. But markets are historically situated and contextual social legal configurations, whose winners and losers are the product, among other things, of legal design. This brings me to my three critical comments or perhaps questions that I would like to offer for discussion. My first question or comment concerns the relationship between legal change and social change, which underpins your account. In the account offered by the book, as I understand it, law appears to be the main driver of social and economic change. I would here like to complicate the special role that law is assigned in the book and ask whether the law is really the driver or whether it simply reflects or follows transformation in society, which may be ascribed in particular to what we may call the culture of capitalism. I ask this because in the book, it's not only that business and finance have had the resources to recruit creative lawyers to code capital. Not only the state has been willing to enforce and give privileges to capital, but also we may say society has gone along with it. Society, including the losers of capital, have displayed a surprisingly little resistance, at least until recently, to the formidable growth of capital coding. Why could this be the case? And in the book, you often mention that capitalists can mobilize a very powerful defense, which is, it is legal. And I think this is persuasive, but I think a set of other explanations can be summoned and perhaps further investigated in future research. It may be the case that the law is simply reflected, or so to say, followed, rather than driven deeper transformations of society. Law and lawyers have occupied spaces which had already been opened up by changes in idea and technology. Capital coders, as you say, have enclosed the code of nature and have kept pushing finance to its limits. But this development could reflect a changing culture, so to say, the changing meaning of what constitutes wealth, what are the acceptable ways to achieve it, and what are the acceptable levels of inequality. And one could also find more unexpected transformation in culture that may have driven the law. So this is my first observation. My second comment or nuance to your argument concerns your discussion of the possibility to fix the system, the way forward, and the policy proposal you offer. And it seems to me your discussion here offers three possibilities, which are not incompatible. The first are the one on which you focus the most, which is constraining the ability to freely and creatively code. So put some restraints on the extravagance of capital coding. Your example of limiting arbitration and limiting private autonomy in conflict of law rules seem to go in this direction. But there is another second alternative which you mentioned, which is the expanding the ability to code in the interest not of capital and capitalists, but other categories. And I think your Maya example goes into direction. So we can bring the technology of legal coding to what we may think as the losers of the present capitalism, small businesses, ethical financial investors, indigenous people, consumer and workers again. And you seem, you mentioned this opportunity, but my impression is you weren't really believing in, you were a bit skeptical of them. Also because you mentioned these ultimately reproduce the logic and language of capitalism. So my third point goes back to this, but I wonder whether we can be more charitable towards these kind of opportunities. The third is the more radical one, which is reinventing the modules, radically redesigning the institution that underpin capital. And here you mentioned two possibilities, the radical market of Whale and Posner and Menke's temporary rights. As you mentioned, these are fascinating proposals, albeit perhaps unrealistic. And on this third avenue comes my nuance or suggestion. I would like to suggest that one option may be not so much to reform the rules top down, but to expand the deliberative infrastructure that allow to challenge, question, and redesign the contour of private law institutions from the bottom. By, for example, privileging the input of outsiders and those excluded by the present market arrangements, as well as monitor the effects of the ensuing experiments. I'm thinking something along the line of democratic experimentalism, and to use the language used by Mangabeira Anger, establishing, quote, a practice of repeated and cumulative institutional reconstruction, which he sees as the only viable alternative to either conservative resignation to the status quo or revolution. And this resonates, I think, with your gradualism and seems to give content to the idea of repoliticizing social and economic life. This may require subjecting legal code not so much to more limits, but to more challenges, so as to produce ultimately more plural market institutions. If I have one more minute, my last point concerns the digital world and goes back to the possibility of empowering outsiders through coding. And it's really spurred by the recent facts of the GameStop saga, where we saw retail investors, I think, using a combination, it seemed to me, of the digital code and what you call legal coding to disrupt the capital coding strategies of the insider, of the incumbents. And I thought this was paradigmatic, interesting, because also they come to the rescue of another supposed loser of capitalism, which is a brick and mortar retailer. So I wonder, are these just distractions, these kind of stories, or do they indicate a real possibility for expanding the technology of coding to outsiders, let's say?
Excellent, thank you very much. And last but certainly not least, Martijn, Hesselink, if I could ask you to take the floor.
Thank you, Doro. I do think it's a great book. It's a very powerful argument. The book is also deeply insightful and perhaps not mentioned yet by everyone, or not, that it's also beautifully written. Which is, I think, truly remarkable. I'm used to reading texts about private law, and none of them matches the eloquence of this argument. So it was really a pleasure reading it. As said, I think the argument is very powerful, and I have no qualms whatsoever with anything in chapters 1 to 8, I would think. So I would just skip these for the moment for our discussion, and then zoom into chapter 9 with comments which go partly in the same direction of what Giacomo just said. So, because in the 9th chapter, you move from, let's say, political economy towards more normative argument, and you offer a wish list perhaps of 8 things that you say, you use the language of that should happen. And you refer to those as rollback strategies at some point, and also as persistent incrementalism. But my first question there is, well, incrementalism towards what? In what direction? What is actually the aim? Because before we start fixing, we need to know what is actually exactly wrong here. It's clear from your book that something's wrong, but the part on what is so wrong about it, the normative part, I found a bit less elaborated. In particular, also, then the question, whatever is wrong, what role private law, if any, what role private law could still play there in fixing it. Now, on the other hand, at least 2 things that transpire through the argument that seem to be wrong. And one is inequality. It's also in the title, but that raises immediately the question, which inequality are we talking about? Is this interpersonal inequality, the horizontal that you referred to in your introduction? And then clearly private law may play a major role here. And that actually we can see even examples of that, how private law can contribute to reducing interpersonal equality, at least in those private law relationships, by transforming private law itself with a term that's usually used in this context, a German term that is used also in the English language nowadays, which is the idea of Materialisierung. So you start understanding concepts like freedom, party autonomy, equality in a more substantive sense, and you don't accept the formal reading of that. And we have seen this actually. We have seen the French law of obligations reform in 2016. I think is a striking example of that trend. Perhaps the German reform of 2002 of the law of obligations, somewhat less so, and certainly both of these are limited only to the law of obligations, but this is something that could be done. However, your book seems to be more concerned with social inequality, let's say distributive justice. And there's a debate on that, but well, perhaps not the consensus, but there's more skepticism about the possibility for private law, which is directly addresses interpersonal, horizontal relationship, the capacity for private law to do anything important when it comes to distributive justice. So whether it can be effective in the first place, and also seen from the other side, when we look at social justice theories or political theories of justice, they usually ignore private law. When you look at Rawls or Sen that you refer to, they don't even think about private law. And this can be the fact that they don't know the code of capital yet. But there are serious issues as to whether you can. So even if social injustice is the cumulative effect, compound effect of lots of interpersonal injustices, it's not clear that by reversing, by materializing, for example, private law, we will avoid concentration of wealth and power in a small number of hands. Alternatively, your concern can be of democracy. You refer to that as well, and it seemed, and also in your introduction, that seemed to be, you said that was actually the major concern, but that's also Giacomo pointed out already. That would lead us in a somewhat different orientation potentially, not so much outcome oriented, but much more process oriented, and try to make sure that we regain control, that there's more collective self-determination. So now we address ourselves in our capacity as citizens, and we will be empowered as citizens. And there too, there were many different possibilities, but then we go in different solutions, but also theories and understanding of what exactly it means to regain control. Are we supposed to no longer be dominated, or is the question of deliberation, of what exactly should we expect? Or a third possibility is that your view is actually it is both, and that the two hang together. And that may refer us to theories like Habermas Theory, who says that private and public autonomy are co-original, they mutually presuppose each other. And so you cannot have the one without the other. So that would be an alternative way of looking at it as well. So my first question then is, what exactly is the main normative concern? What ought to change? And should it perhaps, should it really be merely a matter of rolling back? Shouldn't we also try to move forward in some sense? And then of course the question in what direction? That's my first question. The second question will be shorter and more concrete and specific. One way of looking, but I may be biased here, so one way of looking at your argument is like you're arguing for a European civil code. So now that was a popular idea a decade ago or so. But if we did a European civil code in the right way, right? We did a European civil code based on which enshrined a materialized conception of private autonomy, equality, and freedom. It would be rather comprehensive, including the right doctrines, and most importantly, we would do this in a very deliberative and inclusive way, which I must admit that's not necessarily something that we can count on for the EU. But on the other hand, private law reforms, I mean, EU directives generally are, I think their democratic pedigree is often better than private law reforms in some of the member states. So that is something we could do. Then we could take back democratic control, ensure equality by recoding, in this case, recodifying capital, and it would be an important result for a region in the world, but it might also be a model, if you like, that would compete with the model that you are challenging, because it has almost the exact opposite features. So New York law and UK law are very formal, rather not materialized. They are either made in law firms, as you beautifully demonstrate, or by judges, and not in a deliberative process. So that would actually be a counter model. So my question, very concrete question is, would you be in favor of a European civil code done in the right way? And if so, what would be then the main elements in such a code, in such a new code of capital? Thank you.
Thank you very much indeed. So Katharina, you have a lot on your plate. I think given the comments, we probably have, you have enough for the next 6 hours, but I think you can just choose and pick what you would like to address in the final minutes of this first round. So please, the floor is yours.
So first of all, thank you to all the commentators. These are really very thoughtful and deep comments, and they give me a lot of food for thought. I should also say that I'm working on a couple of strands of these questions or things that I started in the book but didn't really complete in the book already, and having that kind of feedback is enormously valuable. So let me just go back to Katarzyna at the beginning, for example, when she said, why don't you talk about the coding of our behavior? Well, I'm working on a project on data and the digital coding of our data. I've also started writing a couple of papers on that, but I'm working on a larger project with actually somebody who's also a technologist and an economist to bring these different disciplines together. So I think this is really important. People have said that, or the economist, I think, was first coining data as our new oil, and I think that's a wrong conception. But then you have to offer an alternative one. So this is really important. I'm just going to really focus in on the major points of critique. So Katarzyna was also saying that perhaps I could have been more clear about the choice of jurisdictions, where I focus on the global north, which has not been what I've done in the past. I really worked a lot on emerging markets and transition economies, etc. And it's basically tracing the institutions that created our global financial system back in time. It's the kind of reverse engineering approach that brought me to focus on the global north. But as I mentioned to the two students who interviewed me earlier today, Giacomo was one of them already, I do think that the framework has application to the global south, but it would have to be contextualized and analyzed. But I think the hierarchy of claims, the hierarchy of state backing is even more pronounced than the interstate distributional effects that the coding currently has. Why not say anything about Asia or China? I've studied Chinese law. I've also worked with co-authors on China. I think it would actually require a special treatment. But one thing I would say for sure, it's not that China just falls off the cliff because there's no law. China has a vibrant shadow banking system today. Many of the tools that we talk about have been incorporated into the Chinese system. And when it comes to the digital coding, as you know, the state is basically, I think, capturing the capacity of digital coding to manifest its power. And the calling of the recent IPO of Ants is sort of an example for how far the state there is willing to go. But so I think the framing will probably work, but we have to adapt it, and that's sort of another important future line of research. In terms of corporations and sort of the, what was missing, what is happening today, what about CLOs as compared to CDOs? I think the CLOs are perhaps not quite as dangerous as the CDOs, but of course the structure, how they're being created has similar features. It uses the same kind of legal devices that I discuss. And it struck me actually just shortly after the financial crisis. I was teaching with a practitioner, my seminar on law and finance and theory and practice, and we bring a lot of her partners and clients into the class as well. And the first thing they basically told us, well, we no longer do CDOs, we do CLOs. And I just laughed and say, well, so tell me what's the difference, right? So one of the, Dodd-Frank and most of the regulatory interventions, they look at the issuers, they regulate banks. There's a certain path dependency in what we regulate and how you regulate, and they don't touch the private law. So the private law is always sort of the thing that you just assume away, or that's out there, it's sacrosanct. And many private lawyers, including academic lawyers, feel quite strongly about this. And I've gotten feedback that's like, why are you attacking the private law? Just do it through regulation. But the private law is what it is. And what I wanted to show is that the private law is not just what it is, but it's being created and recreated in a certain fashion, and that we have to have an eye on that. How to deal with this, I come back to Martin's question about the European code in a sec, but I think that we have to basically know how the sausage is made before we say how to limit its production or distribute its output. So we have to know how the sausage is made, and this is what the book is about. Is really how the sausage is made. So I think the just one more point on the corporate side. What really concerns me, and I think we've seen this in the COVID crisis, that some of the firms that were already distressed prior to the crisis, that had taken on a lot of debt. I think we have in the US, we've basically moved the structured finance stuff that we use to create securitized mortgages. We have moved this to the ordinary balance sheets of corporations, of ordinary corporations, non-financial corporations. So when you look at the structure that I described for Lehman, we found this in Toya that went under, we found this in Eastern Kodak that went under, we found this in Hertz that declared bankruptcy in May, where they had basically created a financial Ponzi scheme inside a car rental company, and that went under, went basically in distress, of course, when liquidity dried up. And very often you have equity funds pushing that because it's a way to extract value from a firm just before it enters into bankruptcy. So I think it's clearly a space to watch, because it engulfs many more real firms. It's not as systemically risky as when you do this with financial firms like Lehman, but it has major implications for the future of the real economy, of course, if you push this too far. On Giacomo's point, also wonderful comments. So the relationship between legal change and social change is of course a critical one. And I don't want to supercharge the law as sort of an autonomous thing that just evolves on its own. It evolves in a particular context. What was important for me to point out is that in that context, also different groups or individuals can come to the fore and get their capital coded. So we're not stuck in the class divisions in a certain way. Sort of we can have a more mobile society, but mobility means actually having access to our collective source of enforceability. and so the law plays sort of an instrumental role here as well. But you are of course correct in pointing out that this is not autonomous. And without I'm just reading a book about the history of discovering the human genome, right? So when this is basically biological research, genetic research. Had that not happened, the legal coders couldn't have enclose the genetic code, right? So there's a co-evolution that happens here that we have to pay greater attention to, and I fully take on that point. It's absolutely true. And then in terms of the different reform possibilities, constraining the code, rolling back, that was sort of the first argument I made, because I think we need to have more space to rethink. So if we continue basically the picking and choosing of laws by some powerful agents, then as collective entities, as democracies, we just lose the polity space to control. So that's why it has a first order effect for me. So even the bottom-up process that Giacomo suggests following Unger, I think needs space to some extent. You have to be able to create something new in competition with, but you also can't start from the basically backhand position where you don't have the space to do anything. That could be, I think the radical designs, when I talk about radical markets and Menke's critique of rights, in the end, that the typical move that you make at some point, you take some straw man to situate yourself somewhere in between. It's a little bit of a cop-out, I admit that. It was for me the most challenging chapter to write, of course, because I was pretty aware of the shortcomings, but I also need more time, quite frankly, to think this through. So in that sense, one of my next projects will be to write an anchor chapter for a volume on the political economy of coding strategies, and so I will take your suggestions and thoughts really on board and take them seriously and hope that I can make the next move, but I'm still not there yet. I just have to admit that too. Moving on to Martijn's comments and questions, let me just first say, and then several have said this, one of the comments that moves me most is when people say that it was well written, the book, because that was a real struggle, For a lawyer, it's not that easy to write clearly, and it means accessibly. I think it's still easier to do this in English than in German, because there's a tradition here to be a bit more simple in expressing yourself. But I also say this as somebody who's a non-native speaker in English. I really struggled with finding my own voice in my second language. That is not just mimicking how others write, but saying what I want to say in that other language. And I wanted to reach non-lawyers. I wanted to reach lawyers, but I also wanted to reach non-lawyers. So I have rewritten this book multiple times. It's just, you go over and over, and how can you make this even clearer? So this has been a real process. If this comes across, I'm really very, very, very happy to say that. And there might be, substance issues that are even more important than that, but, people wouldn't engage with the book unless you wrote it so that people read it. So which inequality? I think this is the fundamental question here. Which inequality am I talking about? And I think I think it is sort of the compound effect of interpersonal inequality. So this is why I'm tracing sort of these relations between private parties, right? The commoners versus the landowners, who are struggling over who has the better right, and then invoking the state power to ultimately define that by bringing the state in and having the state directly or indirectly side with one of the parties. I think we are creating inequality beyond the interpersonal. We're creating structural inequality, right? Because it's basically having the access to that law, or then enforcing a particular set of property rights over time, and they can't change again. That's Menke's argument. It should be temporary. We don't make it temporary. Once you have achieved that, it becomes a structure of the system, and you build the other systems on top of that. I think that's how I would translate the interpersonal into a social inequality. And the normative concern is this, that we basically vest power, the socialized, centralized means of coercion, but they're really social means of coercion that we have centralized. We vest them with particular interests and then have a hard time taking them back because they can protect themselves with the claim it's legal. This is another point that Giacomo made that might not be sufficient, but I think it's a really powerful one, but also could be a self-defeating one if we can't move beyond just trying to use this as a legit, just a fig leaf for what is going on. I think we are eroding the authority of the law, and I think I'm very concerned about that as well. But so let me just again, I think I said earlier, I think on the normative issue I have to do a lot more work, both in the diagnostic and then certainly in moving forward. Is the European Civil Code possibly a solution if done right? Of course, is the major qualifier, if done right? So I'm not a great fan of big harmonization projects, right? But I do think that we need some common understanding of what rights we want to protect if we are in a common situation such as the European Union. So if done right, setting these norms and standards and making sure that they will be enforced, even if players from outside come and play with things become more complicated, of course, because it's no longer everything territorial, right? So we have digital platforms, and so how to extend modes of ordering, basically, in that fashion is also something that would be a big question. But I do believe that thinking about how to reorder the free picking and choosing in such a way that we can, but also create, come back to notions such as there are enumerated property rights. Certain things get this kind of protection, others don't, would be really, really important. So let me just stop because I see hands are going up in the chat, and I would love to talk to all of you over a nice dinner in Florence tonight, but that won't be possible, maybe in the near future.
Thank you very much. It's really fascinating, and I have to say, so I just want to stress this. This was also one of the reasons why I thought this is a really, really good book also for this multidisciplinary audience that we are having here, because it's beautifully written. And that is rare. It's rare for the legal scholars, I guess, but also for, I'm a political scientist. You don't often find books that are written in such a beautiful way. So let me just stress this. So we have now a little bit of time for the audience. I see, so you can use your blue hands or the chat. And okay, so I can read the chat. There's one chat question at the moment, but I suggest we collect a little bit. So Rona, if you want to start, and I think somebody has to unmute you.
I unmuted myself.
Great, you can do this because I couldn't.
I'm an autonomous Zoom user, apparently.
Excellent.
Thank you very much for this very nice presentation and book that I admit I haven't read it all, but I'm familiar with generally. So thank you very much for this opportunity, and I won't take too much time. I just wanted to comment or ask a question regarding the normative assumptions that you've discussed with Martijn. And this is just a general kind of perspective. So I work more so on inequality from the philosophical side, which is often seen more so as kind of it is often constructed as a form of societal overall concern, or it is addressed from this perspective normally. And I find that, and I'm also a lawyer by training, so, and a lot of times we do see in legal writings, and the legal interest is more so in much more specific problems that we address through more everyday concerns and cases that come before courts at the end of the day, and are just much more specific details that are discussed in those kinds of venues. And of course, it is very hard to kind of connect the two different perspectives. And here's a suggestion. I find that oftentimes when people adopt more so your kind of an approach, which I appreciate a lot, what they often are concerned with is the abuse of rules, of certain rules, or kind of powers that people are given because of their position within the legal system or within certain societal settings and so forth. And I think it is much harder to show that these would eventually lead to overall societal inequality in a sense that we normatively care about, than to point to specific abuses of power that we think are unfair, regardless of whether they bring about such larger inequalities or larger structural features, as you mentioned before. But oftentimes these kind of two concepts are conflated. So I was wondering, maybe it would be like a good strategy in terms of the normative part to focus more so on why those kinds of abuses of power that potentially lead to inequality through the law are objectionable in and of themselves, regardless of bringing about such inequalities. Thank you so much.
Thank you. So then, Joseph, I don't know whether you can also autonomously. Okay. You apparently can autonomously unmute yourself. So please.
Thanks again, Professor and everyone for this wonderful roundtable and on really powerful book. I have one question which somewhat builds on what Giacomo said and Alvaro, which is about somewhat the erosion of the authority of law, but rather how to create or conditions for a reform in a world where knowledge production and ideology, if you will, plays an important role in sustaining certain mechanism, including the legal mechanism. I understand that my reading of your work is that it's more materialist in the way that it is the struggles and contestations and the uses of law by particular groups which really drive the evolution or change within the society. But you mentioned, and Alvaro, Giacomo pointed to that there is the sort of legitimizing power of law, not only which goes in, but it is legal, as you mentioned in the book, but it probably goes much wider, because our idea of law or the rule of law is really grounded in the ideas of autonomy, equality, liberty, etc. And these are powerful tools which are used by those who use the law for the private gain and use some of the modules which you mentioned. And this is I think this is very difficult to go against, because it's not only those who hold the capital and those who are well off, but it's also to some extent academics and some of the intellectual frameworks which we use. Just think about neoclassical economics, scholars, NGOs who operate with these loaded ideas, which can very easily be twisted precisely to preserve the mechanisms which you described as very often leading to inequality or increasing and preserving the inequality. So yeah, something on that. Thank you.
Okay, thank you. There is one more blue hand, Sunita Tripathi. Can you unmute? Yes.
Oh, thank you. Can you hear me, Professor?
Yes.
Yes. Thank you, Professor Pistor. I've enjoyed reading your book, and I'm so glad that you could make time to speak to us. So I'm a student of global governance, but my specialization is in the area of intellectual property law. So when I look at structural inequality of the global governance system, I look at it from the lens of how the trade regime really kind of took over the intellectual property into public goods such as health. And you spend a lot of time talking about how banking sectors and other institutions are affected by those structural reasons. But coming back to the current times, I'm curious to know about your observations given the current pandemic, the crisis, and this propertization of human DNA, and these. So the idea is that China has the data, US has the companies, and Europe has the rules. But from a point of view of global governance, how does this equality mandate seem to be seen as a reform project? You know, how would you see this going forward? I'm not talking in a normative sense per se, but really as a pragmatic view of, do you see the structure changing in any sense because of these institutional playing around and these actors influencing them? Given that the law is losing its legitimacy, institutions are losing their legitimacy, the public is losing their patience. So how would you, some comments on that would be very encouraging. Thank you.
Thank you very much. So I have one question in the chat, and then with this, I suggest that we close the round of questions. So this is from Eugenia Ralli in one word. Thank you very much for this extremely interesting book roundtable and for organizing it. If I may, I would like to ask in general how, under which criteria, Professor Pistor identifies incompleteness of the law vis-à-vis flexibility, or in other terms, freedom of action in generally. For example, freedom of contract provided, secured, or protected by law. Thank you. Okay, so you have the floor.
Yeah, thanks again.
Katarzyna?
Thanks for a really good, wonderful question. So Rona's question at the beginning about the relationship, if I understood it correctly, between abusing power and inequality as separate strands of inquiry and in evaluation. So I think that's helpful. I think I'm also thinking about the creation of power in a way. So again, my image of the state has also changed in writing this book and thinking about these issues. So if we think of power as having access to a common resource, which is the centralized means of coercion. We used to have them all, and we did our own feuds and fought each other, and then we centralized them to create inner peace and maybe also create resources for fighting outside. So the access to this resource is critical for exercising power in a legal way. We can also still use physical power. And the question, of course, is the identification of abuse is really complicated when the real exercise of power rests on the ability to access the common source of power. And I think this also goes to Joseph's point a little bit, is that the legitimization function of this is legal, and I've overstated this in the book a little bit, but we have created this notion of this close imbrication of what is justice and what is law. Some languages, German, of course, Recht, and is both justice and the law. Others sort of disentangled this a little bit more. But this is a powerful thing, not only in terms of actual coercion, but sort of the legitimization of the means that are being used. In that sense, sort of the power question is right in here. And then the question, of course, is how power aligns with inequality, and whether inequality is only of concern if it's a result of the abuse of power. I think, at a certain level, inequality could be a concern even outside of it, but I think I'm looking at the interaction, but defining the abuse, and maybe I'm just too much of a lawyer there, defining the abuse when it is couched as legal is much harder. And I think one of the things I was trying to do in this book is to show that there can be certainly a misuse of these legal devices, but we have enabled them. So we have to think about how to bring this back, because that's part of the system we have created. And sort of the silence of, I think Giacomo mentioned this earlier, the silence of the workers, the customers, the ordinary people is deafening in the sense, but of course we can also tell a story why they have been silenced or have not been part of this. I think in general, the private law stuff is not anything we ever debate. Many reforms are smuggled into a bankruptcy code without much debate because it's technical and complicated, and there's a small epistemic community that really knows how it works, and they do the thing. It doesn't have the kind of salience that other things have, and I think that has to change. And some of my goal for writing this book was, I was really thinking we have to look at the underbelly of capital, right? And that's where the private law hangs, and we have to understand it. So just one point on the on Joseph's question about the knowledge production and the sustaining of the ideology for all that. I mean, yes, I completely hear you. It's really hard to work against the stream. I do find, however, that, for example, my students have changed over time, and not because I have changed my teaching. I have done that, of course, as well, but also they come from a position of much greater uncertainty about what's going to happen in their lives. And how to create a future. And I taught corporations last term. I had 170 students on my screen, and about a third of them said, when I asked at the beginning, that they want to engage in critiques of capitalism, which I haven't had before. So a third is quite significant for Columbia Law School, which is one of the feeding schools for the Wall Street firms. So, I think there is hope. So if we have an interactive dialogue, and of course, as I say in the book, they still have to get jobs. We still are charging $65,000 a year for legal training. These are structural things that have to give as well if we really want to make a change. So this also goes back to an earlier question, so what can we do in academia? I think we have to think about our own institutional contributions for maintaining and sustaining the systems, and have to see where we can bring change in. Sunita's question about global governance, what is a real global reform project? One would hope that the COVID crisis would shake us up and do a real global reform. And one of the most frustrating things is the treatment of intellectual property rights over these vaccines for me right now. So I think what we should have is basically a true global compact where I would say we share this resource, because we are all sitting in one boat, and the weakest members in the globe will put us at risk again, because that's where the virus is going to spread and might actually mutate and come back and haunt us. So you would hope that this is, where we just get our act together. I still have some hope that it's going to happen, but we're not quite there yet. We're seeing more, nationalist backlashes and infighting and trying to, export restrictions, and that's all just fundamentally counterproductive. So I think we have to harness again some normative principles that were built into, for example, the German Constitution. Somebody asked about the post-war era. I think learning the lessons from not only fascism, but also from the 1920s, why fascism and communism came about, brought us a more restrained model of capitalism and some normative foundations built into the German Constitution, where it says property rights is not only a right, it's also an obligation. And it also has to serve the public good, right? So if that is true, then this could also extend not only to citizens in Germany, but could extend well beyond that. And I wish politicians were more proactive in using that. Is this realistic? Well, right now, it's a hugely political issue, but that's where basically our fate lies right now. And I think NGOs and advocates moving from below and saying, we have to waive trips for this particular issue at the very least. And of course, we're not doing it because nobody wants to set the path that this might happen in the future, but that's exactly what some of us would want. So we want to push for reforms right now, take this as an opportunity. I hope we can get there. And then lastly, last but not least, Eugenia's question about incompleteness of law versus flexibility, etc. So I've written a paper in 2003 with Changgang Xu about incompleteness of law, basically transposing the theories of incomplete contracts to law, and saying, well, if you start from the premise that law is never complete, then you have to think about who has to have the law enforcement powers. And we were thinking less at that time about the law-making powers that I identify with the codas of capital here. So I would basically say incompleteness of law is inherent because we never can see or foresee all future contingencies, but there's room for discretion. How flexible the law can be on certain issues and how much room you build into the law for private choice and making it malleable, right? There's something that we cannot control there because it's inherent, but there's also a matter of choice. And I think on the choice issue, we should rethink some of the flexibilities that we have allowed to emerge in our private law systems to facilitate the coding of capital.
Thank you very, very much. So that concludes this part of the event. So I'm really very grateful to you, Katharina, and to all the participants in the panel, and also to the public for a great discussion of a wonderful and great book. And for all of you who haven't yet read it, go get and read it. I mean, I hope you are all now very convinced that there is a lot in there. We reconvene with a few people who have signed up for the behind the scenes workshop in, do you want 10 minutes break?
That'll be fine.
Okay, so in, let's say a quarter to, what is it? Yeah, a quarter to 7.
Yeah? Good. Okay. Thank you.
Perfect. Thank you very, very much.
Thanks, everyone. It was really a great pleasure to be here. Thanks for your comments. I took a lot of notes, so I'm sure this will get into my work. Thank you.